What if everything you've been working towards, settling in the UK, getting permanent status, finally feeling secure, is suddenly moved out of reach? What if the promise of 5 years to ILR becomes 10 years or more? Today, the UK hasn't abolished ILR, but proposals have stirred fears, confusion and deep concern among millions of migrants. This is what you need to know: what is true, what's being proposed, and what it could mean for you. So what is ILR and what is the current situation? ILR, or Indefinite Leave to Remain, is the UK immigration status that allows someone to live in the UK permanently without time limits, with right to work, access to many public services, and a path towards naturalization or citizenship. Traditionally, many visa categories allow settlement ILR after 5 years of continuous lawful residence, but in May 2025, the UK government published a white paper titled Restoring Control over the Immigration System, which contains proposals to change a number of immigration and visa rules, including extending the qualifying period for ILR from 5 years to 10 years for many migrants. These proposals do not yet represent law. Many details are still under consultation. That means the rules are not enforced and many things are unsettled, including who exactly will be affected, whether current migrants will be subject to the new longer wait, and what exemptions or reductions may apply. What proposals are on the table? So let's break down what the government is proposing around ILR and related settlement changes. The first is qualifying period extended. The standard time period required to gain ILR is proposed to go from 5 years to 10 years under many parts: workers, skilled workers, and so on. There are discussion of an end settlement model, meaning some people might be able to reduce the waiting period if they meet certain criteria: economic, social contributions, and so on. The exact criteria are not yet cleared. 2. Exemptions and protected routes. Some visa routes would be exempted from the longer wait. Example is partners of British citizens, victims of domestic abuse, those with post-Brexit rights under the EU settlement scheme will keep their rights under existing agreements. So the third one is effect on family, work, and other categories. Migrants on worker visas, skilled worker routes, uncom BN holders are among those likely to be affected. There are concerns about increased cost, visa renewals, NHS surcharges, and so on. Uncertainty, psychological stress, and potential or exploitation when people are in limbo. 4 is retrospective effects. What about people already in the UK? One of the biggest controversies: will people who are already partway on 5-year route to ILR have to wait longer, that is under the new 10-year standard? IPPR research estimates that as many as 1.7 million people currently in the UK are en route to settlement and could be forced to wait longer under the proposals. Government has not confirmed for sure yet whether the changes will apply retrospectively or whether transitional arrangements will protect people who are close to qualifying under the old rules. Because the proposals are still developing, a lot of misinformation is circulating. Let's clear up what is not true, at least not yet, versus what might be, what people are saying. Is it true or proven? ILR has been abolished. False, it has not been abolished. The proposal is to change the time requirement. ILR remains part of the immigration system. Everyone already on 5-year route will lose their rights. Reset to 10 years, unclear. No final decision yet. Many people are calling for protection on transitional rules. Only new migrants will face the 10-year rule, possibly but not guaranteed. Some sources suggest existing visa holders may also be affected. Government will need to clarify there is no chance for earlier settlement under the new model. That is false. The end settlement idea is built in to allow reduction for contributions, though we don't have clear details. Who could be impacted and what are the stakes? This change, if implemented, could have widespread effects both for individuals and for society at large. Numbers involved: IPPR estimates 1.7 million people in the UK on routes to settlement could see longer waiting times. This includes workers, those on family and dependent visas, uncountable BNO holders, and so on. Financial burden: visa renewal fees, NHS surcharges, application fees add up. More time waiting equals more renewals, more cost. For some, this cost may be prohibitive, leading to people staying in limbo or being unable to apply. Psychological and life planning impacts: uncertainty around when if one qualifies for ILR can affect decisions about education, jobs, home, personal relationships. For migrants who came under the assumption of a 5-year route, changing expectations halfway feels unfair. Integration and societal effects: ILR is not just legal status. It provides the ability to work without visa restriction, access public funds, move jobs, participate in civic life. Delays in ILR could slow or hinder integration. Extended uncertainty can increase vulnerability to exploitation, e.g. in jobs, housing, if someone doesn't have status. Impact on citizenship and rights: since naturalization, citizenship often requires ILR first. Delaying ILR pushes back paths to citizenship. That has implications for voting rights, consular protection, and so on. To keep things clear, here is a snapshot of what is known versus what is still unknown. What we know, or nearly sure: the UK government has proposed extending the qualifying period for ILR from 5 years to 10 in many visa routes. Some visa categories will be exempt: partner or British citizens, victim of domestic abuse. Some others, there is public debate, political sensitivity, petition, and strong opposition from migrant advocacy groups and think tanks. End settlement is a proposed idea that people performing certain contributions may qualify sooner than 10 years. What is not yet decided or unclear: whether the changes will apply to people already in the UK, retrospective application, or only to new entrants after implementation. The specific criteria for end settlement: how many points, what counts as contribution, and so on. The date when any changes will take effect, or how long the transition will be. What you can do if you are affected. If you are a migrant in the UK or considering moving, here are some steps you might take to protect yourself or plan accordingly. The first thing you need to do is check your visa category and how far you are into the ILR pathway. Know whether you are under a route with a 5-year or with a longer pathway. Estimate when you would have qualify under old rules. It might be good to gather documents in advance. 2. Stay updated on government announcements and consultations. The white paper is not final. There will be a constitutions. Respond or get involved or through advocacy group to ensure voices are heard. Watch for official Home Office statements about retrospective application, transition arrangements, exceptions. 3. Prepare financially if changes go through. You may need to cover extra visa renewals, fees, or longer residence before applying for ILR. Budget accordingly. Consider legal or immigration advice if in doubt. For advocates, join affected groups. Group migrants' rights organizations, NGOs, legal clinics are already raising concerns. For instance, around fairness, cost, rights. Supporting or following their work can help. Petitions, some already underway, expressing opposition to extending the ILR period for certain routes. 5. Gather documentation, keep records of continuous lawful residence, employment, paying tax, community contributions. This might matter if end settlement criteria are applied. Ensure you comply with current rules, visa renewals, overstays, and so on to avoid jeopardizing your eligibility. Broader reflection and risk. It's also useful to look at what this might mean beyond individual stories, fairness and trust in the system. Many urge that changing the rules are mid-journey for people who came under different expectations threatens trust, both for those who have invested time, money, lives in the UK under one understanding, and for future migrants. Economic implications, skilled workers, international students, people willing to contribute socially and economically may reconsider when and whether to come to the UK if the route to settlement becomes much longer. Social cohesion and integration. Uncertainty can stall integration. People with less security tend to have worse mental health, less civic participation, less ability to plan long term. Legal retrospective application of immigration rules changes can raise legal, ethical, constitutional questions. There may be challenges. To be crystal clear, ILR hasn't been abolished, but what is happening is a proposed shift, longer waiting times, possible cost, and major uncertainty for many migrants. Whether that becomes reality depends on how the government finalizes the white paper proposal, whether there are fair exemptions, protections for people already here, and transparency in what counts as end settlement. If you are affected or think you might be, stay informed, gather your documents, and if possible, reach out for advice. The rules might change. You don't want to be caught unaware. If you find this information helpful, kindly like, share, and subscribe, and I'll see you in the next one. Bye.